Good morning, class. Welcome to our third guest lecture of Intellectual Property Law with Prof. Nikolaos Voutyrakos. I hope everyone is doing well and remain in high spirit for our guest lecture today. My name is CJEU and I will be the host for this lecture. This guest lecture is brought to you by Faculty of Law, Universitas Sumatera Utara. Today, Alhamdulillah, we meet again with our wonderful lecturer, Prof. Nikolaos Voutyrakos from Jindal Global Law School, India. I believe all participants and I will be benefited from insightful topic related trademark law masterclass, how does trademark function, and we will talk about case study too with Prof. Nikolaos Voutyrakos. Without any further ado, please welcome Prof. Voutyrakos. The screen is yours now, Prof.
Thank you, Cheryl, and hi, thank you everyone for joining me for another IP class, masterclass. This is our last masterclass in the context of this lecture that we're doing. So after doing a general overview of IP, after doing copyright, after doing patents, today we will finish all this discussion with trademarks, which is the last part of this IP umbrella that we're discussing all these weeks. Now, I'm sending you now the handout that we're going to use today. So as always, it's in Word format so that you can edit there, keep your notes there. And as you will see in the end of this handout, I added something extra, trying to connect everything we did together. So I created a table at the end of the handout where you will see some common characteristics of IP and what makes them different when it comes to copyright, patents, trademarks. So this is also in Word format. So even the table you can edit yourself, if you want to use it for later on, if you do any IP related research. So you can edit this table as well. So I think it will be pretty useful for you guys to contextualize everything we discussed so far. So today, guys, we're going to move to a slightly different IP right. A slightly different IP right, and I'm saying that even though IP as a whole has become very commercialized, and I feel you must have understood that throughout our classes so far, when it comes to trademarks, even the whole logic behind trademarks is commerce. So it's not something like patents that we discussed last week, that we start by creating something that is so useful for society. So we get a patent for that, and after 20 years, this useful creation, this invention that we made becomes part of the public domain. Trademarks are not like that. Trademarks are not that useful, someone would say. And remember, guys, a couple of weeks ago when we started our classes, when we were discussing Starbucks as a case study, to see how many IP rights are found in this very simple thing, in this very simple brand, which is a word that we're going to be using today here and there. And when I ask you, what is the first thing that comes to your mind when I tell you Starbucks? Before I tell you, that Starbucks has so many copyrights, has so many patents, a couple of you said the trademark, the mermaid, is the first thing that comes to your mind. This is because trademarks are built that way to draw you and me, to draw consumers in order to be attracted to this product. So what I'm going to explain to you today is, why do we need to protect the Starbucks mermaid? Why do we need to protect trademarks? And also, what exactly is it that we're protecting? Because yes, trademark might sound like something very simple. In trademarks, we have the opposite problem that we had when it comes to copyright and patents. Copyright and patents, even what we protect here is very simple. We had to have so many conversations to understand what are these works that we protect in copyright. What are these inventions that we protect in patents? These are things that are, even the subject matter of patents or of copyright is a little difficult to comprehend. In trademark, the problem is the opposite. The subject matter, what exactly we're protecting through trademark, seems to be very simple, a little bit too familiar for us. If you look around you, you will see trademarks everywhere. Even if I show you my juice, you will see a trademark. If I show you my phone, you will see a trademark. If I show you my moisturizer, you will see a trademark. But it cannot be as simple as that, as you can imagine. But have in your mind throughout our conversations that in all this consumer-driven economy that we're living, trademarks are everywhere, are in places where you cannot even see them, because people are becoming craftier and craftier, more clever. So they want to have more and more trademarks. So it wasn't enough to have a trademark over, let's say, the Apple logo on the phone. After a point, they said, why can't I have a trademark over the shape of the phone as well, so that nobody can copy me? Why can't I have a trademark over the color of my products? There are some products that have very distinctive color. Or why can't I have a trademark over a sound? So you will see trademarks are becoming more and more complicated for us lawyers to deal with, which is why I think we have to understand exactly what is it that we protect here, and most importantly, where should this protection stop? Because you understand, giving a trademark over a shape or over a color is a very strong monopoly to give. So if we're going to give it, we have to think very carefully before doing so. So having that as an introduction, go to your handouts, guys, to start discussing this in a little bit more practical way. So skip the introduction. The introduction I keep the same in every handout, the general IP stuff, and go straight to the trademark part, which is at the end of page 1. So the most straightforward thing that we're protecting here, obviously, is words. Adidas, Philips, Levi's, Volvo. Very simple words, words that exist, words that are invented, it doesn't matter. Directly, when you hear Adidas, you know what we're talking about, even though Adidas is not even a real word. Same with Philips, Volvo. Directly, it creates an association to your mind with a company, with a brand. This shows a successful trademark. And this is the simplest way to go about it. But you can see even in this very same picture of these, what I call word marks, I have a slogan, just do it. Familiar slogan, eh? Nike. One of the most famous slogans that we have when it comes to international commerce. The moment I tell you just do it, many of you will think of Nike and how they commercialize their products. So, yes, simple words we protect here. Yes, slogans potentially we protect here. But not only that, remember the mermaid. Logos. Logos, to put it more fancy, I call them figurative marks. Figurative marks, just a fancy way of saying logo. Okay? Even the Lego one, the second logo that you can see in your picture, the Lego one, trademark as well. Nobody can copy this because it's registered under the company owning Legos. So, word marks, figurative marks. Words, slogans, logos. But maybe also a combination of these two. Check the Nike. You have the word mark, Nike, and you also have this check, this tick, figurative mark. But Nike uses them together. Another way we can have trademark protection. Coca-Cola. You know, when you see these white italics Coca-Cola, and you know directly what product we're referring to. This shows how strong this trademark is, how many associations it creates to our minds the moment we see Coca-Cola. Nonetheless, in reality, things are not always that simple. Check the pictures I have right below. The 3 stripes, Adidas. Should Adidas be able to register these 3 stripes as a trademark? Rhetorical questions, because this is a trademark. Next, Toblerone, the chocolate, or think of Kit Kat. Should Kit Kat be able to register the shape of the bars, of the chocolate bars? More problematic now, because if we give protection to Kit Kat, you understand that nobody else can create such chocolate. It's only Kit Kat. Yes, but to give a trademark to Kit Kat, we have to make sure that when I see this chocolate without the Kit Kat packaging, I can directly say, this is a Kit Kat. Because if I cannot say it, we cannot give a trademark for that, because the public, the consumer, which is me, does not directly associate the shape with the brand. So we have to be a little bit more careful. Red Bull. Red Bull wants to have a trademark over the combination of colors. These blue and silver colors it has on its cans. Should it be able to? Similar considerations here. So the moment we start opening our trademark discussions, you already see that there is a danger that we give a monopoly through trademarks that is very strong. This means we have to be very careful whether we should grant this trademark or not. Now, let me take you a little bit and explain you, first of all, what exactly are we going to protect here through trademarks and through trademark law. And second of all, a familiar discussion for us until now, why should we protect trademarks? Are they really so important to deserve protection through trademark law? Because trademark law, very strong protection, a similar logic to copyrights and patents. Exclusive rights. You can exclude everyone else from using your trademark if you have one. So very strong protection to have. So how all this conversation started, guys, is centuries ago. And trust me, I'm not going to take you down through history lane, but I'll tell you a few things that I think will be very useful for our discussions. So the logic behind trademarks is very simple, a bit too simple. Imagine back in the day, I am a farmer, I'm a shepherd, okay? And I have my animals. The easiest way for me to distinguish my animals from the animals of the other farmers is to put a tag on my animals saying Nikolaos, saying my name, making sure that I'm not going to lose my animals or confuse my animals with the animals of the other products, or to make a less, like a more realistic example, more contemporary example. I am a trader. I'm an investor from Greece. And I want to send you guys some goods, some products from Greece to Indonesia. Nonetheless, you understand how many dangers I'm going to face shipping my goods from Greece to India. Most importantly, my goods may get destroyed, may get stolen, may get damaged, may get lost. So, to prevent all this from happening, I put my name in all my goods, saying that this, Nikolaos, to make sure that if my goods get lost and I have to go and search for them, I am going to know which my goods are because they're going to have my name on it. So the logic is as simple as that, guys. This is what we're trying to do with trademarks. We try to distinguish our goods from goods of other people. Obviously, the markets gradually become a little bit more competitive. And this is where the problem starts. And this is where the law has to intervene. Because the moment the markets become more competitive, you have many players. You have many players competing in these markets. Yes, I am making a juice, but after a point, there are other people making juices as well. So we're starting to compete with each other. So after a point, I put my name on my juice or my brand name on my juice, not only because I want to distinguish my product from theirs, but also because I want to make sure that my clients know that my product, my brand, has certain characteristics. Think of a very simple scenario. Why would I spend all this money to get an Apple phone? Why, while with half of the money, I could get a phone from another company with the same characteristics, the same technical features. Why would I spend $1,000 to get an Apple phone? I don't need it. I can get the same characteristics in a phone with $500. Why do I do that? Before moving on, do you have any reason for me? Why do I choose to pay so much more for a product, even though I can find the same product for half the price? I can get a Samsung phone for half the price. Why do I get the Apple one? Is there something in the trademark that attracts me? What is it exactly that drives me to make this choice that hurts my pocket? Why would I hurt my pocket like that? What is it that I want to achieve by choosing a certain brand over another?
The quality, Prof. The quality of the products.
Perfect. Thanks, Cheryl. So another feature now is not really to show the origin of my product. Yes, I put the Apple logo, the beaten Apple, to show the origin of my goods, that they come from Apple. But it's not only that I want to show anymore. I want to show that my product comes with certain specifications of quality. My product is better than theirs. So if you want a better product, it only makes sense that you are going to pay a premium. Nonetheless, this is a little bit of not theoretical, a little bit of artificial argument, because what do we want with trademarks? Ideally, perfect competition. A market where competition is uninterrupted, undistorted. But in perfect competition scenario, we have more and more people competing, so better quality and lower prices. This is what competition says. Nonetheless, is this really what we are achieving? We don't have much competition. Because of how trademarks operate now, very few companies have all this budget to create a phone. And IP is very responsible for that. If I hold my phone and my phone has 5 trademarks and 10 patents in it, and you understand that it will be very expensive for someone to get a license over all these patents, all these trademarks, and make a new phone. So we have ended up with 10 players making mobile phones because nobody else can. At the same time, phones keep getting more and more expensive. Is this really the competition that we want to achieve? This I'm leaving here is more of a philosophical discussion, but with many commercial implications. But yes, isolating the legal argument there, yes, trademarks started because we wanted to show the origin of our goods, where our goods come from. But gradually, we started showing also the quality of our products, how good our products are. If you're looking for something specific, you don't have to look at the product, look for the brand, because the brand is a guarantee of quality, is a badge of quality. You don't even really care about the product anymore if you think about it. Gradually, the product takes a backseat. And what goes in the front? The trademark. The brand goes in the front now. The brand is really what you're buying now. So, with that in mind, gradually we move in a time where from a badge of origin, from a source identifier, the trademark started becoming a salesman, started having a life of its own. So the trademark, firstly, started to define the product. First thought. But second thought, if you think about it, after a point, the trademarks also started defining the consumer as well. Imagine if I tell you two very simple statements I'm going to tell you. First one, I'm driving a Suzuki. Second one, I'm driving a Ferrari. Imagine I tell you two things that normally shouldn't say anything to you. Your brain shouldn't make any association by the mere fact that I mentioned two trademarks and the fact that I'm driving these cars. Nonetheless, because this is how our mind works by associations, immediately you're going to think so many things of me when I tell you that I drive a Ferrari or that I drive a Suzuki. This is how trademarks are becoming the product now. They're defining the product and they're defining us. They're defining the consumers at the same time. Because the consumer who buys a Ferrari is very different from the consumer that buys a Suzuki. Good, different, bad, different. We're not going to make any assessment. That doesn't even matter here. But even this very simple example that I gave makes you realize how good of a salesman trademark has become. And why, going back to our first week discussion, we keep paying $6, $7 for a coffee at Starbucks. Because we're paying the way they leverage their IP. We pay for their lawyers to go and fight in the courts for these IPs, to go and register these IPs. Now, coming back to the trademark story. With trademarks, guys, we protect, as you must have realized, two things. First one, most straightforward, we protect goods. We protect products. Most of the things we have discussed so far. Adidas, Nike, Coca-Cola, all these things we've said. But also, guys, we protect services as well. If you see the yellow M directly, you know what this is, McDonald's. If you see, I'm loving it, I'm loving it. What is this? The most simple sentence ever. Yet everyone knows this is the McDonald's slogan. So, directly when you see the M or the slogan or the clown, you know, that they have as the mascot, immediately you know this is a fast food restaurant. So if you're looking for these specifications, I want to eat something fast, I want to eat a burger, I want to eat fries, I want to eat something unhealthy, you only have one trademark to look for, guys. So it seems like for you as a consumer, trademarks make your life very easy. We're going to discuss this a little bit more when we talk justifications in a bit, like a little bit more philosophically, but now I try to address it as simply as I can, because this is a simple conversation. This is things that everyone thinks when it comes to trademarks, if you contextualize them all together. So, goods or services we protect here. Now, when it comes to how long do we protect them? Because for copyright, we said, most jurisdictions, obviously these are domestic contests, but I try, as always, to refrain from going to specific laws because it doesn't matter. IP laws are similar in most countries. With copyright, we said 70 years after the death of the author is usually the term of protection for copyright. For patents, 20 years. After what? After the registration, because in patents we have registration, so everything is much easier. In trademarks, guys, we have an exception to this very strict rule that we know that you cannot renew your IP right. So trademarks, you have a protection for 10 years. So it looks like the smallest protection we have, only 10 years. Nonetheless, bear in mind that if you manage to register your trademark, you will be able to renew it every 10 years. The only thing you have to do is you have to show that you actually use this trademark. So, remember this always for trademarks. It's the only IP right that can be renewed perpetually, okay, if you use it. This is not the case for patents. Never will you be able to renew a patent, even with this trick. Remember when we discussed last week, evergreening and these kinds of things. Evergreening should not be allowed, modifying your patent a little bit and saying, oh, I came up with something new. In trademarks, this is perfectly allowed. And why? Because, okay, trademarks do not serve the strong social function that patents serve or copyright serves. we give copyright because we know that after the copyright expires, the good, the work will become part of the public domain. We give the strong protection to patents because we know after 20 years, the patent will be a common good. For trademarks, do we need that? Do trademarks even serve such a strong social function? Theory says no. So, if someone wants, you can renew your trademark forever. So keep this in mind, guys, in any event. Now, to start building a little bit our discussion of how exactly does a trademark function. We said already the two main functions of trademarks. Let me tell you, this is not the whole story. But bear in mind, yes, the two more simple, the two more straightforward functions of a trademark is first, origin. Through the trademark, I want to distinguish my goods from the goods of other people, of other undertakings, origin function, and secondarily, quality function. Through the trademark, I want to imply that my product, my brand, comes with certain quality standards that some clients that don't mind paying a little bit more will be okay to give. Now, when it comes to quality, don't think of it as something very straightforward necessarily. Because yes, I got this t-shirt from a specific brand because it has a good fabric, let's say. Nonetheless, you understand that quality may mean different things for different people. For instance, when I have my sunscreen, my moisturizer, you may have seen in your moisturizer that it will say vegan or cruelty-free, or this product was made without torturing animals, without torturing people, without child labor, respecting human rights, all these things. Does this really have to do with the quality of the product? My moisturizer would be the same even if animals were tortured. It has, guys, though, because for me, it's very important that my moisturizer is vegan and cruelty-free because I want to put my money where my morals are. For me, quality means certain quality standards, which does not mean only a good quality moisturizer that will have good consistency for my face. It also means a good moisturizer that will not have tortured animals during experimenting. So for me, it's very important that my products are cruelty-free. This is quality for me. So I wouldn't mind paying a premium if I know that the conditions under which this moisturizer was produced were the ones that I want for my products. Okay, this is also under this quality umbrella. Not only because this product has a good fabric. Yes, obviously, this is the more simple way to go about it. But quality means so much more. Quality can go all the way through the supply chain. After that, origin, quality. I think so far this must be more or less straightforward. Cheryl, at any point you may interrupt me if you think you may need to translate something. Continue. Third function, advertising. Remember before when I told you that after a point and how after the mass media and all the radio, TV, the internet now more recently, brands are becoming, we see them everywhere. You go out on the street and you see brands everywhere. So through the trademark, I want to inform consumers about what my brand is all about, and I want to persuade them to go and buy it. So this advertising function starts to become more and more important when it comes to trademarks, because trademark is your salesman now. Trademark works as a commercial tool. Trademark draws consumer closer to your brand if your advertising is good. Which is also the reason why, as you may have noticed, advertising is becoming wild sometimes. Especially when, let's say, have you seen the ad with Pepsi and Coca-Cola that the kid steps on Pepsi cans to reach the Coca-Cola? So it can be very fierce sometimes, the competition, especially when you use someone else's product to show that yours is better. This is common, and these are lots of trademark cases that we see in the courts or in arbitrations now. So origin, quality, advertising, and last but not least, function, investment. Through the trademark, I want to make a reputation for myself. What does reputation mean? Very simply, I want to have a loyal consumer. I want to have a loyal clientele. How will I do that? By creating a whole ecosystem and dragging the consumers inside. If you buy an Apple product, you will realize that after a point, it will be very comfortable for you to start buying more, because Apple has created a whole ecosystem to make it very convenient for you to work around having an iPhone, a MacBook, AirPods, iWatch, and everything they're selling. In isolation, maybe you wouldn't get all these products. But because they work so well with each other, and because now Apple has trapped you within this ecosystem that it has created for you, now there is no going back. If you see all the surveys, people that choose Apple become loyal to it. Very unlikely they're going to leave their MacBooks to go back to Windows. And trust me, this is not a product placement. I'm not trying to advertise Apple, but I think it's a very good example to show you how a trademark can trap you within this whole system that Apple has created. Any question, guys, so far? Is everything clear before I move to the justifications?
Sir, I want to ask something.
Yeah, tell me.
First of all, I would like to introduce myself. You can call me Shifa. Okay, so I saw that you try to say that there is an advertising, and there is some cases in the arbitration that say maybe that two international brands, two famous popular brands are having argumentations. So I would like to know how the arbitration solve that problem. Is that to giving some money, or yeah, I want to know how to solve that problems.
Okay. Sifa, in general, in IP, you can ask a specific types of remedies. We mostly ask for two. One is injunction, interim relief. So what do you do with an injunction? You go to the court or to the tribunal, but mostly to the court, because interim relief, it's mostly you go to the court for it. And you say, please, something is happening very urgently. You have to stop that party from violating my trademark. Injunction will only do that. The court will say, okay, you have to stop whatever you're doing because this is not working. Second is, you go to the court and you ask for money, for damages, to put it more legally. So you say, in a trademark scenario, but it's the same with copyright and patents, but in trademarks specifically, you say, you have violated my trademark, you have infringed my trademark for this time. What you have to prove for infringement, we will see in a while, so I don't want to spoil anything. So you say, you are using my trademark, I'm selling phones, and I'm putting the Apple logo. They're not Apple phones, they're mine. I just put the Apple logo. I'm confusing the consumers. I'm lying to the consumers, basically, that they're buying Apple. They're not buying Apple, though. They're buying Nikolaos with the Apple logo on it. So Apple has to sue me, clearly, for that. And Apple has to prove, how much am I damaged for it? How much money did I lose for it? And for how long is Nikolaos violating my trademark? So calculating these two, the court will tell you, you have to pay this much money for damages. So these are the two main remedies we have, either injunctions, when you have something very urgent the court has to resolve, or damages that you would seek in any type of a tort scenario. You know, IP infringement is a tort. It's as if you would have a defamation, you know, something like that. It's the same kind of logic on your claim. Okay? Perfect. But a small asterisk, hold that thought, because we have to discuss infringement more specifically a bit later to see when exactly is it infringed. Because my example is obviously very straightforward. Yes, I'm putting the Apple logo, but I'm not Apple. So yes, clearly I'm infringing here. But cases are not always so straightforward. So, after all this, guys, I think I must have convinced you that at least trademarks are an important part of our lives. They also have some different functions. Is this enough for us to justify their protection? Is it enough to say, okay, they are important, so we're protecting them? And this goes back to this very classic discussion that we do all the time of justifications. Remember natural rights, utilitarian, all these things we discussed both in copyright and in patents. Now, today, I want to make this discussion a little bit more adult and focus more on the arguments. Because it's very simple to understand, okay, natural rights theories, hey, you deserve a trademark as of right, because you made it, because you are the creator, you are the businessman. Utilitarian theories, hey, you deserve the trademark because you do something that helps the society. So the society has to give you something back. It will give you trademark protection over this thing that you create, over your brand. This is the overall logic. Now, trying to specify it a little bit, because this sounds a little bit general like that, I'll try to tell you some arguments that are most commonly used for trademark protection. Some more convincing than others, clearly. And you will be the ultimate judge to decide if you agree with them. So, first argument says, very simply, I want to protect the consumers. I want to protect the consumer that wants to buy Apple. I want to make sure this consumer ends up buying Apple. Not me. Not this. Not this. It's Apple I want them to buy. How do I guarantee that? By making sure that I have very strong trademark laws to protect Apple. To make sure that Apple is in a position to enforce its trademark against any potential infringer. Now, at the same time, I want to protect Apple, but I want to protect the consumer also. I want to protect the consumer because, remember before when I told you that the way trademarks operate now makes our choices much simpler. Because I think, what do I want? Let's talk Coca-Cola. I'm a consumer. I want to drink a cola-flavored, caffeine-infused soft drink with a distinctive taste. I know directly where to look. I have to look for the Coca-Cola white italics. So, to put this in more fancy words, law and economics theories tells you that trademarks reduce consumers' search costs. Because me as a consumer, I don't have to search that much. I can directly refer to the trademark to get what I want. So my search costs become less and less and less and less. This improves competition. This is what we want. A perfect competition scenario. Many companies competing with each other, so they have to increase the quality and decrease the prices to become more competitive. This is what, in principle, we need to do with trademarks. Now, is this theory bulletproof? In my opinion, no. Because, guys, if you really want a perfect competition scenario, in a perfect competition scenario, ideally, you can only have one brand. If you have only one brand, there are zero search costs. Think of a communist scenario. You don't have trademarks, you don't have all that stuff. You have one product. Zero search costs. So if it's really competition that we want to increase, competition with so many companies in the same market increases search costs. If we only have one product, this is where the search cost would actually be zero. We wouldn't even have to search. At the same time, yes, in principle, this is correct. When it comes to trademarks, they help the consumers a lot make more informed choices. But are these choices so informed, really? Think of how advertising works nowadays. Advertising manipulates your mind, tells you what you need, creates the demand, and then tells you, I have a supply for your demand. Yes, but I never had this demand. You convinced me that I need this product, of so fiercely advertising it to me. I never needed this product before. So the way advertising works nowadays doesn't really serve this social purpose, this social utility that we would like an IP to serve. Remember how strong social utility work was when it comes to patents we discussed last week? Where is it when it comes to trademark? When you see an advertisement with a product, then you buy the product, you realize it's nothing like what you saw in the advertisement. Is this really what we're trying to achieve here? So, not that this argument is not correct, but I'm having some second thoughts to really buy it. Second line of argument. Remember all these theories? I don't want to go through the theories again because I think in trademarks it makes more sense to talk money, to talk commerce. Remember all this reward theory, incentive theory. You need the trademark as a reward because of how good it was. You need the trademark as an incentive so that you keep creating more and more and more. All these classic natural rights theories, logic. These theories in the field of trademark tells you, you put so much effort to create this trademark. This trademark is so good and has all this commercial magnetism in it. It draws consumers to you. For that, we'll give you a trademark so that at least for 10 years, or if you want to renew it potentially forever, you will have some protection over it. Now, while this again has some merit to it, again, I'm a little bit skeptical because remember when we talked about copyright, what did we say in copyright? The most important concept is originality. When we talked about patents, most important concept, novelty. We need something new. Otherwise, there is no patent. Patent for what? For something that already exists. You need something new compared to what existed before that, the state of the art that we said last week. There is no such requirement when it comes to trademarks. Your trademark doesn't have to be new. Your trademark can even be the word Apple used for mobiles. It can be a common word. So, while some trademarks may be invented, novelty is not a requirement here for protection. So I don't think it's that big of a deal to give a trademark protection over what? Of using the word Apple for mobiles. Okay, I don't think this is that creative. But it doesn't have to be. Trademark doesn't want creativity. Trademark doesn't want novelty, doesn't want originality. Trademark only wants distinctiveness. So if you want to think of the keywords like copyright, originality, patent, novelty, trademarks, distinctiveness. When it comes to trademark, we only care that I can distinguish your trademark from the trademark of another person. This is more than enough for you to get a trademark. It doesn't have to be original, it doesn't have to be novel, nothing. Okay? At the same time, through copyright, we said copyright is very important because it's a good incentive for the creator to create more and more works, scientific outputs, artistic outputs, doesn't matter, that the society wants. Same is the case with patents for obvious reason. But is this the case for trademarks? Does society really need more trademarks? I would say not really. Society will be the same with or without more trademarks, with or without trademark protection. I can have the Apple logo. Why should I have a legal protection for it? So, while all these arguments that we've been discussing so far also potentially apply to trademarks, I want you to have in mind that you should have some second thoughts when it comes to these justifications, because it's not a given that we should be protecting trademarks, or it shouldn't be a given that we should protect them to that extent. Nonetheless, to be fair, what you should also always keep in mind when it comes to trademark is that one would think that, but isn't the protection very strong here? We protect the word Apple. Is it possible that the company Apple has a monopoly over the use of Apple? The answer is no. Apple has a monopoly over the use of Apple for a specific category of goods, for electronics, let's say. So, if I make this bottle and I write Apple, it's very likely that this is fine and that Apple cannot sue me. So, trademarks are a very strong monopoly, yes, but only in relation with a specific category of goods or services. Okay, so it is a strong monopoly, but Apple cannot use the word Apple for any kind of product out there, only for the kind of product it has registered it, which is electronics. Okay. Now, at the same time, other than these pros and cons and the justifications and all that stuff that we're discussing, trademarks create some additional issues. Issues that in your handout, I have called them social costs. So, first of all, simplest one of them all, logistics. I have to pay to register the trademark because, again, we have registration here, like we did in patents we discussed last week. I have to pay for dispute resolution, to defend my trademark or to go against someone who is infringing my trademark. All this costs money, but also it creates additional costs to other people in the market, to other traders, to other competitors of mine, because trademarks create monopolies. Yes, Apple cannot use the word Apple for everything, but if someone uses the word or the logo of Apple for electronics or for whatever categories Apple has registered this logo, Apple can directly sue them. And these big companies will take you to the courts very easily because they can afford it and because they have nothing to lose, only to win from that. They can even use the trademark to harass people, to keep competition out of the market. This is a very common strategy for big companies. I take to the courts all my competitors because I want to abuse my dominant position in the market. So this creates competition law issues. Now, a final, little bit more theoretical remark is, obviously, as you can imagine, trademarks coming up with a good trademark is not very easy. Because even from our conversation so far, you understand that some trademarks are better than others. Some trademark sticks to your mind more easily. So, coming up with a good trademark, then registering it, because it's very easy and pretty cheap to register a trademark, means that gradually we're going to run out of trademarks. So gradually it will be more difficult for us to come up with good trademarks, especially if you're having in mind that you can have your trademark forever. In this context, I have added a passage in your handout. This handout is a little bit more advanced compared to the rest because I think your understanding now should be a little bit more advanced than in the previous classes. At least I hope so. I have added a passage from a case that went to the courts, which was initiated from Mattel. Mattel is the company that created Barbie, and is one of the companies that loves to go to the courts, will take you to the court for anything. Mattel is very litigation friendly. So Mattel sues Aqua. Aqua used to be a band back in the day, in the 90s, that had a song that was called Barbie Girl. You know, I'm a Barbie girl in a Barbie world. You must have heard the song. So Mattel, the company that made Barbie, sued the singers, saying you cannot use the word Barbie in your song because I have a trademark. And Barbie is a trademark, is registered. Yes, but how does it matter? They're using it for their song. They're not selling dolls for it. Like this would be okay in a copyright scenario, but not in a trademark scenario. Trademarks only refer to goods or services. You don't have a protection over Barbie in general. Copyright would give you that. But because obviously it couldn't get protection of Barbie through copyright, it tried through trademark. It got trademark protection, but you cannot forbid someone from using Barbie in their song. You don't have control over the word Barbie, only in relation to the goods or services for which Barbie is registered. Okay, this is very clear for you to understand, guys, because otherwise you may think that trademark is a bit excessive of a monopoly. It can be, but not necessarily, because it's inherently limited by the categories of goods that you registered it for. Okay? And because I keep mentioning registration so much. Registration, guys, I remind you, we discussed it in patents as well. I also remind you there is no registration for copyright. The first time that you will have to prove you have copyright is actually in the court when you defend it or when you're suing someone for it. But for patents and for trademarks, you have to go and register. Register very simply means you go to your trademarks office in your country and you say, I want to register the word Apple for electronic products. The person there, the registry, will tell you, okay, can you please give me some specification? Do you want a word mark? Do you want a figurative mark, you know, a logo? What exactly do you want? You have to be very precise with that. After that, they will go back in their database, they will check, is there something similar to that? Or is there something wrong with your sign for which it cannot be registered? If there's something wrong with your sign, or if your sign is similar to something that already exists, very likely they won't give it to you. And this is very important, guys, because the same considerations we have when it comes to infringement of trademarks. But if everything is okay, they will register it, and then your 10-year protection will start. And potentially, you know, renewal, and this is where your trademarks lives forever. Now, obviously, the logic of registration is very good. It wants to minimize your costs. It tells you, yes, you will pay some money to register your trademark, but you will be able to see a database where you know all the trademarks that exist out there in Indonesia, let's say, for the goods or services that you want to register. So if you see there is something out there already, and you are not going to register. Or conversely, if you already have a trademark, you have to check this database to see if your trademark is getting infringed by someone. Because it's not very likely that you're going to see really Apple logos, you know, going there. But you may see a sign, you may see a mark that is similar to yours. So you are not sure. You think this person might want to infringe, but is it really? Would a consumer be confused when he saw these two next to each other? Would they think that this came from me? These are the kinds of considerations we have to do when it comes to trademark infringement. Now, the main problem, in my opinion, with registration is that you can register a mark without having to prove that you are using it, without even having to prove that you are going to use it. So what happened in practice? People started registering trademarks, never use them, and let's say I go to Indonesia, I see, is there a Coca-Cola trademark registered? I see for whatever reason there is not. I go and register it for me. Can I do that? Yes. Coca-Cola doesn't have any protection for its trademark in Indonesia if it hasn't registered it. IP is a domestic concept. You don't have an international protection. So I go there and register the Coca-Cola trademark for myself. First reason, why would I do that? Because I want to copy Coca-Cola and start selling Coca-Colas and earn money. Straightforward scenario. Another scenario, though, a more sneaky one, is I don't want to sell Coca-Colas. I want to sell this one, my own drink. And I want to make sure that I keep Coca-Cola out of the market. So I register the Coca-Cola trademark for me. I never want to use it, but I don't want anyone else to use it as well, because I want to sell my own drink and have a monopoly over this market. So this happened a lot when it comes to domain names. Domain names is just an online trademark, www.coca-cola.gr, let's say for Greece. For Indonesia, must be something similar. Many people started doing that to the extent that in domain names, this has become a profession for some people. This is what they do for a living. They register a domain name, www.coca-cola.in.gr, whatever. And when Coca-Cola comes to Greece, it says coca-cola.gr is already registered with me. Coca-Cola comes to me and it's like, what's happening? How did you do that? I said, why not? I can do it. I know IP rights. And I say to Coca-Cola, because I'm a good person, I will sell you my Coca-Cola domain name and give me $5 million for it. This is what happened with Facebook. When Facebook became Meta, Meta was already registered in the US. Facebook paid $2 million to the person having the Meta trademark so that it can buy it. So imagine, in domain names, this has become such a big issue that you have people that have this as a job. They're called cyber squatters, and this is what they do for a living. They register domain names, and then they sell it to the legitimate owner when they decide to come to this country to export. Very big problem, guys, and very dangerous, but very good level playing field for us lawyers. Let me tell you. Now, since I'm talking so much about selling and renting and all these kinds of things, remember in the previous weeks, both of them, I think, we talked about licensing and we talked about assignment. Does someone remember what these things are? Because the same conversation happens in the field of trademarks as well. Do you remember what is licensing? What is assignment? How can you commercially exploit a trademark? What can you do with it commercially to make money out of it? Does anyone remember? Okay, very simply, guys. Have it in mind like that. First, assignment. More straightforward. I register a trademark. After a point, I realize I'm never going to use it, but someone else might. I sell it. Assignment means selling. I give the ownership to the buyer, to the person who buys it. Now, licensing means renting. I have the Coca-Cola trademark, since we're talking about that. I realize that I can be very profitable if I can rent my trademark to other people. What do I mean rent? Very simply, allow other people to use it by paying me some money, of course. So I can make money by using the Coca-Cola mark, but at the same time, I can make money through other people using it. And this is good for me because at the same time, more people get to know about my brand. So I get to benefit many different ways from licensing. Okay? So licensing, very simply, renting, assignment, selling. In assignment, you give away the ownership. In licensing, you keep the ownership. You just allow other people to use your mark. Clear, guys? Don't get confused with the jargon, with the terminology at this point. Now, let's go to infringement to start talking a little bit more specifically now. The easy thing in trademark is the moment you go to register your trademark, the same exercise the trademark registry will do is exactly the same exercise we're going to do at the level of infringement, of potential infringement, if we want to prove if someone infringes our mark. The only difference is between at the level of registration and at the level of infringement is at the level of infringement, the product is already out in the market. So you have to prove that all these things that you have to prove during registration happen in the course of trade. That's the only difference. But what do you have to prove? When there is something wrong with the trademark, when can we do something about it? Now, I have done this, I think, in a very nice way that I hope is not confusing in your handout. I have divided the grounds for infringement into 3 different categories. Absolute grounds, which are the simplest, relative grounds, and what I have called dilution. So absolute grounds, relative grounds, dilution. These are the 3 grounds that we have for infringement and for denial of registration. So absolute grounds, very simple. There is something wrong with your trademark. With the trademark you want to register, you shouldn't even have a trademark for this. So it should be denied registration. Or if for whatever reason it was given registration, it should be stopped now because there is something wrong with it. Absolute grounds. Relative grounds, there is something wrong with your trademark, but not in itself, in relation to another trademark. Your trademark looks similar to someone else's, or your trademark is identical to someone else's. So, absolute grounds, something is wrong with your trademark in itself. Relative grounds, something is wrong with your trademark in connection with another trademark, an earlier trademark. Let me tell you what I mean. Absolute grounds, simplest ones. In your handout, I have added a very simple, generic definition of, what is the subject matter of a trademark, so that you understand that if we don't have any of these distinguishing characteristics, you cannot have a trademark, or if you had it for whatever reason, if you manage to register it, it should be denied registration. So this is on page 6 to help you. Right under absolute grounds. I'm quoting. Trademark means a mark capable of being represented graphically and which is capable of distinguishing the goods or service of one person from those of others and may include shape of goods, their packaging, and combination of colors. Now, first requirement. Your mark, your sign, should be able to be graphically represented. So, what does this mean? Very simply, when you go to register your trademark, and you need to show me what exactly you want me to register. You cannot describe it to me. And why is this important? Because many people, guys, started going to register the smell of a perfume. They wanted to register the sound, the ringtone, the Nokia ringtone, let's say, was the first one that tried to do that. So, after a point, the law had to intervene and say that, yes, but if I cannot describe in writing what exactly you want to protect, how can I give you a trademark for it? Can I give you the trademark over the smell of rose? And you understand, this is too much. You don't have a monopoly over the smell of rose. Let's be honest, you didn't even create the smell of rose yourself. You just used it to make a perfume. So, what we call in these weird words graphical representation very simply means that I need something tangible. I need to see it. You cannot go and trademark the smell of your perfume. You cannot go and trademark the taste of your food, which, by the way, both of them people are trying to do all the time. So, For that, the only help we have, which I have also added in your handout, is this Zikman criteria. So Zikman, it was just this case that was about registering a smell of a perfume, which failed in the end. But the court, this is from the European Court of Justice, but it doesn't matter. It's we use it everywhere at this point. So the court gave you this criteria as to when is a trademark properly represented graphically. And it says the representation is clear, precise, self-contained, easily accessible, intelligible, durable, objective, blah, blah, blah. So I need to see it. If I cannot see it, if you cannot explain to me what exactly you want to register, you can forget it. You're not getting a trademark for it. This is one, graphical representation. Second one, from the definition that we read, capable of distinguishing the goods or service of one person from those of another, or something like that. Or we called it already distinctiveness. Your trademark has to be distinctive. It has to help people distinguish your goods from goods of other people. The origin function that we said before, the most fundamental function of trademarks. If your trademark doesn't serve the origin function, if it doesn't have distinctiveness, it's over for you. But first question we should answer here. Who will decide if a mark is distinctive enough to be registered? Who will say? We need someone to do that. We need a test. Remember in patents last week, the person skilled in the art. And we need something similar here. And we have, in trademarks, we have the average consumer. The average consumer, guys, is your best friend in trademark exercise. Any kind of trademark infringement scenario you are assessing, you are not assessing it from your own perspective, you are assessing it from the eyes, from the perspective of the average consumer. Now, who is the average consumer? Just a random person with medium level of IQ, but very importantly, who operates in this specific market that we are examining now. And why do I say that? Because, guys, the average consumer of juice is not the same as the average consumer of cars. Because the average consumer of cars is going to spend so much more money to get the car. So the standard for the average consumer for cars or for luxury goods or for all these things, the standard is much higher for the average consumer. Because if I am the average consumer for luxury bags, let's say all these Gucci and Louis Vuitton and all these things that get imitated all the time in the streets, my standard of care, my duty of care as the average consumer of luxury goods, as someone that is going to invest $5,000 for a backpack, is much higher. I will be very attentive. I will be very careful to see if the product I'm going to buy is potentially fake. So the average consumer standard is much higher for these kinds of goods. If I want to buy a juice, am I really that careful? Will I really notice if the juice that I'm buying is the original one? I will probably even buy the wrong juice by mistake. So bear in mind that the average consumer for luxury goods is very attentive, is very careful not to be confused because you're spending so much money. So you wouldn't be confused so easily because trademark infringement is all about confusion, guys. Okay? So first question, we decided who will tell you about distinctiveness, who will tell you about confusion. It's the average consumer all the time. Now, little help that we have when it comes to distinctiveness is if you go to page 7 of your handout, I have added a very nice picture. I didn't make it. I took it from a blog post online. But it's a picture from a case, a US case but we don't really care about the facts of the case because they're really simple. But this case is very nice. This is Abercrombie and Fitch versus Hunting World. Very old case, but gave us what I have called the spectrum of distinctiveness. So even before when we talk justifications, you remember we said, okay, some trademarks are better than others. Some trademarks sound better. They sound like you put a little bit more effort to make them. So even without the average consumer, even before going to the average consumer and how they would perceive this trademark, even the trademark itself may be distinctive or may be less distinctive. And we have, if you see in the picture, 5 different categories of marks. Starting from the right, from the most distinctive ones, which it calls fanciful, mostly invented words. See the examples below. Adidas, Uniqlo, words that didn't exist. What else? Kodak, the cameras. Invented words that didn't exist. They only got created because they became trademarks. So these are considered to be the most distinctive, obviously. So this means that these are the easiest one to prove infringement, because it's not very likely that someone else came up with the same invented word as you did. So it will be much easier for you to prove distinctiveness. Moving to the spectrum, to the less distinctive side. Arbitrary. Arbitrary are also good, pretty distinctive. Arbitrary very simply means ordinary words, everyday words, but which are used to describe something very different. Apple, that we discussed before. Yes, Apple sounds like a very basic trademark, but not when it comes to electronics. This is what makes it arbitrary, and this is what makes it descriptive. Amazon, same thing. Amazon sounds like a very simple trademark, something that normally you wouldn't give protection for, but it is used for online retail services. Why not give it to it? Pretty arbitrary, pretty distinctive. Both fanciful and arbitrary, pretty good. Then starts the problem. Suggestive marks. Now, suggestive marks have a characteristic which refers to one of the characteristics of the goods. So imagine if I create a company and I want to sell fridges, refrigerators, and I call this company Penguin. It's clear that I refer to a characteristic of the product, to a characteristics of the fridges, the fact that they are cold. That's why I called my company Penguin. These are the trademarks that most of the times will cause problems in practice, because you will have to prove how that the average consumer will think that your trademark is distinctive enough. I have a couple of examples here in your handout. TripAdvisor. TripAdvisor normally doesn't sound very distinctive because this is what it does. It gives you advice for your trips. So normally this wouldn't be accepted as a trademark, but in the eyes of the public, this is pretty distinctive. So fanciful, arbitrary, suggestive, most of the times are okay. The other two are the problem. Descriptive, generic. Descriptive signs, generic signs will not be registered, guys, because both of them have issues. What are descriptive signs and why can they not be registered? Descriptives are very simple trademarks that designate the quality of the product, the kind of the product, the geographical indication, the geographical origin of the product. So imagine if you make a product and you call it Indonesian shrimps. You cannot do that. This is a descriptive mark. This will never be registered because it indicates the origin. It indicates the source of the products. This is a descriptive mark. Descriptive marks are a huge no. Generic marks, same logic. By the way, when it comes to descriptive, I have in your handout a case where actually a mark that, in my opinion, was very descriptive was found by the Court of Justice of the European Union to be very okay. So if you go to page 7, but I don't want to spend much time for it, I put this for someone who may want to dig a little bit deeper. I have this Baby Dry case. Baby Dry was just a company that created the diapers, for babies, and called them Baby Dry. Now, based on what we said about descriptive marks, a Baby Dry should never get a trademark for it. Because it's very descriptive. It shows you what the product is doing. It keeps your baby dry. It's a diaper. Nonetheless, the Court of Justice, imagine now this case reached all the way to the Court of Justice of the European Union. But, okay, this is another story. But the Court of Justice said that this is okay. This is not descriptive. Because it says, in the English language, we don't use the words like that. We never put the noun before the adjective. We would say dry baby. We wouldn't say baby dry, which is what the company is told. So it's not descriptive because someone would immediately understand that this is not how the words are ordinarily used. Now, very weird explanation, in my opinion, but have this in mind because it's an interesting way to go around all these descriptive marks discussion. Now, generic marks, also very problematic. See the pictures I have here in your handout. With generic marks, guys, the problem we have is that we have some trademarks that started very nice. Like the first one, yo-yo, Vaseline, aspirin. Nonetheless, after a point, this product, these trademarks started describing a whole category of goods. So now, when we talk about aspirin, we talk about any pill. When we talk about yo-yo, we think about any toy that does this process that a yo-yo does. When we talk about Vaseline, we talk about any kind of such cream with this thick consistency. So these marks, even though they started as distinctive, after a point they lost their distinctiveness and they started describing the whole category of goods they refer to. These are generic marks. And these cannot be valid trademarks anymore because they lost their distinctiveness. Now, if we reverse this, think about the reverse, the opposite scenario. Sometimes you have a trademark that starts as a very generic trademark, but for whatever reason in the eyes of the public, after a point it is considered to be distinctive. And I have used KitKat as an example. KitKat, guys, is probably the most litigated chocolate in the world. You will have Nestlé and Cadbury having decades of fights of, is KitKat a trademark? Who owns this trademark? Because both companies wanted to issue similar products. But Nestlé said, no, KitKat is mine. I made it, and I think the shape of the KitKat should be a trademark. Cadbury said, but you shouldn't be able to register the shape of the KitKat. This is ridiculous. You could, though, according to the court. And this is true, the concept that is the exact reverse scenario of generic marks. So generic marks, we said, were the ones that were distinctive, but then through use became non-distinctive. The opposite one, marks that were not distinctive, but through use became distinctive, so KitKat, is this concept that I have called acquired distinctiveness. So distinctiveness that was not there in the beginning, KitKat was something that you would never be able originally to register as a trademark, but gradually, because it became so distinctive in the eyes of the average consumer, always in the eyes of the average consumer, now it's a perfectly fine trademark. This is acquired distinctiveness. This is when it comes to absolute grounds. And this is, trust me, the easy part. Now, relative grounds. Relative grounds, I told you, your trademark has something wrong in relation with another trademark. What it has wrong? Two scenarios. First one. Your mark is exactly the same as the other one, and it is used for the same category of goods. So, same marks, same goods. I'm using the Apple logo to sell computers. Obviously, Apple will sue me for that because I'm not the owner of this mark, Apple is. This is what we call double identity. Double identity means identity of marks, identity of goods. Both the marks and the goods are the same. This is the most straightforward scenario, and to be honest, the least common in practice, because nobody would be so naive to use this like that. Second scenario, and more common, is what I have called confusing similarity. Now, in confusing similarity, you don't have exactly the same mark, you don't have exactly the same good, but you have a similar good and you have a similar mark. But if you want to prove confusing similarity, you have to prove similarity of marks, similarity of goods, and you have to prove likelihood of confusion. Likelihood means, possibility of confusion. The average consumer needs to be confused when they see these two marks that are similar. If the average consumer is confused, then confusing similarity, infringement. Now, comparing the two marks is usually pretty simple. You just put them next to each other and compare them. But the goods, how do you compare the goods? Because if I have a company, let's say Dior, or some company that makes, perfumes. Let's say there is Dior. I make a similar smelling perfume like Dior, but I don't use the smell for perfumes. I use it to make candles, scented candles, for the houses. Are the goods similar here? Because we have perfume on the one hand and candle on the other hand. Are the goods similar in this scenario? What do you think?
That's hello, sir.
Hi.
Yeah, I'm Sarah. I want to say that you said the similarity, the confusing similarity, yes, that we have because of the commerce that we know that many of using electronic commerce. So we know very many of trademarks that can be the official market, that cannot be the official market too. So we know everything is the problem of the commerce. So it can be the liability of the intermediary, yes. Because the seller is not the person who makes. Just now that you said you can sell that the Kit Kat or Coca-Cola, that you can be the intermediary too, because very many people in Indonesia, we have shown that they have do like that to sell in the electronic commerce. So the liability of the intermediary for make the shown very shown the trademark, the good trademark, because we have known justice has also become the important part of establishing a balanced position between the seller and the consumer. But now, if have the problem again of the trademark, we have known who is the very important liability. That is the intermediary person, because the consumer have using it. I use that Kit Kat and I want to eat Kit Kat. I buy it in here, but in there, this is Kit Kat too. Which one is the best? You have said yes. The copyright we must show the copyright, yes, and the other one. So how is the intermediary liability? Thank you, sir. I just want to.
Yes. Okay, Stella, I think the case study that we have for the end will answer all your questions, because the problem we have here is twofold. Let's say the most classic scenario is, let's say, even in case where there is no confusing similarity, I make imitations, perfume imitations, okay, like copies of original perfumes. I take Chanel number 5, let's say, which is a very distinct like smell that we have in mind. I make an imitation out of it. I go and I start selling it. I don't sell it as Chanel number 5. I'm not trying to confuse anyone. I'm saying I have copied Chanel number 5. You know, there is no confusing similarity. All the customers know they're not buying Chanel number 5. They're paying 10 times less to get my imitation. Yes, but is this something that the law should allow? Is this possible that trademark law is limited to confusing similarity? The answer is no, which is why if we don't have double identity, if we don't have confusing similarity, which we don't in this scenario either, we have a third one, which is the one that is called dilution. I'm writing it in the chat as well, but it is in your handout also. So if you go to the end of page 8, see what I have there for you guys. This is another really famous trademark, Tiffany & Co., one of the most expensive jewelers in the world. Have in mind all these discussions that we did in the beginning of the class and how trademarks works nowadays, where the trademark doesn't really tell you only buy this product, it tells you how you should live. It sends you psychological messages, you know, luxury, lifestyle. It tells you how you should live your life. This is what trademarks are doing now. So you have this trademark. I want to infringe this trademark, or I want to use it to my advantage because it's a very well-known trademark. So dilution can take 3 different forms. Let me try to explain it to you through a couple of examples. Have in mind Tiffany & Co. is your main trademark here, okay? First example, I open a restaurant and I open it and I call it Tiffany & Co. Will anyone ever get confused that this is the same as the jewelry store? Probably no. There wouldn't be any confusing similarity. One sells jewelry, the other sells food. Nonetheless, even this is problematic, because imagine gradually the average consumer that will go to Tiffany & Co. and then will come to me. After that, when they think Tiffany & Co., they will not only think of the jewelry, they will also think about my restaurant. This means that gradually the Tiffany & Co. trademark is losing its distinctive character. It's losing what made it so strong in the first place, this commercial magnetism. This goes away. This is the first instance of dilution, one that we call blurring. Blurring, which I have written in your handout, means detriment to distinctive character. After I open my restaurant that I call Tiffany & Co., the original Tiffany & Co. loses its distinctive character, loses its uniqueness, which is what made it so popular. So this shouldn't be allowed, even though there's no confusing similarity here. It's clearly we operate in completely different sectors. Second scenario, Tiffany & Co. Again, jewelry. I open a place, I call it Tiffany & Co., but it's not a restaurant anymore, it's a strip club. Will anyone really again get confused that this is Tiffany & Co., the original high-end jewelry store? Nobody will get confused. But by naming my strip club Tiffany & Co., I damage the reputation of the original, because then the average consumer will have a negative impression where they think Tiffany & Co. and then, oh, then someone opened a strip club and named it the same way. This is what we call tarnishment. tarnishment is detriment to the reputation. This is what I do with the strip club. So blaring is the one when I have my restaurant. Tarnishment is another one when I open my strip club. Third instance of dilution, and the most straightforward one, free riding. Free riding very simply means I take unfair advantage of someone else's trademark. What I told before about the perfume imitation. Will anyone ever confuse my fake Chanel No. 5 perfumes with the original? Nobody will confuse because I make it clear to them. I even write it on the bottle. This is a copy of Chanel No. 5. Nobody is going to think they're buying the original, which is most of the times the case. Even when you go out in the street and buy these fake Louis Vuitton bags, do you ever think that you're buying the original? Never. Would you ever pay so little money for the original? Probably never. So it's not really confusing similarity that is the problem here anymore. The problem is dilution. The problem is you're harming the original trademark, either through blaring, through tarnishment, through free riding. It doesn't matter, but all of these are problematic, and the law fights against all of this. So when you think of trademark infringement, don't have in mind only, strictly confusing similarity. Yes, this will be the most common, but you don't necessarily need to prove confusing similarity to prove trademark infringement. You may have dilution. In dilution, you don't need confusing similarity. Now, the case study that I have, even though now we have used many examples, but I think it's nice to discuss this as well because it's a recent, conversation. If you go towards the end during the case studies section of your handout, we have a couple of cases, but they are from the same set of facts. They are two different cases, but the story time is more or less the same. So I chose this because I think it will be familiar to all of you. You go on Google and you Google something. Many times, you must have seen in the beginning, the first few links are not the things that you Google. They are some sponsored links, some ads that Google gives you just because you have paid, someone has paid some money to have this prioritized on top in the search results. So this is a tool that Google gives people that it calls AdWords. So what Google allows you to do is to buy certain keywords, and the moment anyone Googles, let's say, Louis Vuitton, the first thing that comes is whatever your website is, because you have bought the keyword, and it will refer you there. Google, on its part, will say this is a sponsored link, like on the top right or top left, like remember, depending what browser you're using. Google will tell you that this is a sponsored link, but it will give you 2-3 results first. That is not what you Google. So after a point, people start abusing that, as you can imagine, because Google, for whatever reason, allowed the same keyword to be bought by different people. Don't ask me why. Just Google obviously wanted to make lots of money. So they said, hey, we have the Louis Vuitton keyword. Anyone can buy it. So the first problem, the first set of cases that Louis Vuitton started against Google was because Louis Vuitton Googled its name, and Louis Vuitton has many trademarks. Louis Vuitton, Vuitton, LV, all these are registered trademarks for Louis Vuitton. So it Googles Louis Vuitton, and the first link it finds is a link that sends you to buy imitation, to buy fake Louis Vuittons. So Louis Vuitton, all very friendly to the courts, takes this to the courts of France. Goes all the way to the Supreme Court. The Supreme Court of France didn't know what to do, sent the case to the Court of Justice of the EU. So, first possibility, go directly against Google, against the intermediary. What do you think? Is the intermediary liable in such a case? Is Google liable for this? for allowing this sponsored link to be prioritized and send you directly to the fake Louis Vuitton website? Is there liability for Google in that case? Would Louis Vuitton succeed in its claim? Because you understand here we have two sets of claim. One can be against the infringer, against the person with the fake website, and the second one against Google. Louis Vuitton said obviously against Google, if I win, I will take much more money. So I'll directly go against the intermediary because, to be honest, Google should have known all this was happening. And if Google didn't know, again, it's responsible for not knowing what's going on in its own website. So should Google be liable based on what we have discussed on trademarks? And then we'll discuss the second case, which is going not against the intermediary now, but against the infringer itself, against the person who buys the keyword. Tell me about Google first. You have any ideas?
If the Google announcer, if the Google, this is the intermediary of the networking of our communication. So we can know which one is the best, because in Google we have Louis Vuitton, very many of Louis Vuitton out like that. We show which one is the best. So which one is the best? Not only the best, but which one the trademark is the right. Like just now you say to us.
Yes, but is Google liable for this? Is it Google's fault that all this was under its sponsored link?
Yeah, if I want to the liability of the Google, maybe the internet, the communication person of the minister communication, they have shown to us how is the liability of the Google. So very many people use the Google in the right case, not in the wrong case. So we can know which one is the best part like that, sir. Maybe in Indonesia like that. In another word, different again.
Okay, let me tell you, when it comes to Google, the court very quickly said you cannot go against Google because Google doesn't infringe your trademark. To infringe a trademark, the first thing you have to know is you have to use it. Google doesn't use your trademark. Google is just a host provider. It's just the house where everything is happening. But Google is very passive in all of this. Google doesn't do anything. So Google doesn't use the mark in the course of trade, which is what trademark infringement is all about. To infringe a trademark, you have to use it. You have to do something with it. You have to sell it. You have to say it's yours. You have to do something about it. Google just was the place where all of this happened. So Google doesn't use. So this was enough for the court to say Google is not liable. Nonetheless, even when someone tried to go against the person who bought the keyword, the person who actually used it, because it bought a keyword, so it should be liable, even this was problematic. So in the second case, you have two huge companies. We are in the UK now. You have Interflora. Interflora is like the biggest place in the UK to deliver flowers throughout the country. Okay, it's like Amazon, but for flowers. And at the same time, you have Marks and Spencer. Marks and Spencer decides to open a branch to deliver flowers, to start doing the same thing that Interflora does because it was very profitable. So to do that, Marks and Spencer starts buying all the keywords that were about Interflora. So now, if someone Googles Interflora to go and shop from their website, the first link they're going to see is Marks and Spencer. So, obviously, Interflora wants to sue. But this case is after Louis Vuitton versus Google, because Interflora knows it cannot sue Google anymore because it will not win, because Louis Vuitton already lost. So Interflora said, okay, I'm not going to sue Google, I'm going to sue Marks and Spencer, because Marks and Spencer bought all the Interflora keywords, and now I cannot even Google my name because I will be directed to Marks and Spencer website. So even in this case, guys, which is, you know, one of the reasons I wanted to talk to you about these cases, even in this case, the court said, no, Marks and Spencer is not liable because Marks and Spencer is not fooling anyone. You will see, yes, when you Google Interflora, yes, the first thing you will see is Marks and Spencer because Marks and Spencer bought the keyword. But Marks and Spencer, nobody told you that it is Interflora. You can clearly see this is Marks and Spencer we're talking about. You make an informed choice if you want to click on Marks and Spencer website. Marks and Spencer didn't confuse you by doing that. Marks and Spencer used the commercial tool that is available out there. So if we want to promote competition, which is what we allegedly want to do through trademarks, all this keyword advertising that Google is doing with the AdWords is helping competition, is making companies become more and more competitive with each other. So the court said, this is fine. If there is no confusion and everyone knows they're going to go to Marks and Spencer if they click that link and not to Interflora's website, this is not trademark infringement anymore. You have to hate the game, don't hate the player. This is what the court essentially said. So, overarching conclusion for both, you cannot go against Google because Google does not use, and you can also not go against the person who buys the keyword because it doesn't confuse anyone. It just gives you priority over the search results. But this is it. Is there something that is ethically bad? Is it something that is immoral? Yeah, 100%. Is it something that is illegal? No. On the contrary, this is something that the law promotes. It promotes fierce competition. We want to promote competition here because that's the whole logic behind trademarks. That's all from me, guys. And bear in mind the table that I told you at the end of the handout, that I try to put everything that we discussed together, copyright, trademarks, and patents, and address it through different issues: registration, subject matter, protection threshold, ownership, infringement, term of protection, defenses, blah, 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 blah. Okay? And this you can expand based on your own readings, but generally I use these tables a lot because I think I like structure in my life. But guys, I don't have anything else to tell you. Sorry for taking a little bit longer today. But I hope you found the discussion for trademarks a little bit, I found it interesting, even though I know it was a little bit more complicated.
I think they're just confusing, Prof. A little bit. Yeah. Prof, thank you for the informative presentation. Maybe because there are some person already asking in the middle of presentation of you, I just want to ask one more question, Prof. About likelihood of confusion. Like we all know, we often see the substantial similarity between the one trademark to another's, right? So how court determine the likelihood confusion, Prof? Usually, is it the strength of the mark or the marketing channel use or what? Thank you, Prof.
Yeah. Okay, Cheryl, to prove confusing similarity, you have to prove three things. First one, you have to prove the marks are similar. But for the marks, is always the easiest part of the exercise because it's a paper exercise. You just put them next to each other and basically compare them. Second one, where the problem starts is you have to compare the goods now. Because the goods, most of the times, will not be the same. And what are similar goods? Is a bag similar to a perfume? Is a perfume similar to a scented candle? Because you might use a similar trademark, but if you use it for a different good, it's fine. We don't have confusing similarity because you need both similarity of marks and similarity of goods. The only help that we have when it comes to comparing the goods is these so-called canon factors from a case, like a canon case, that tell you some factors that you need to take into consideration to compare the two goods, like let's say perfumes and scented candles, to say are they similar to each other, is what is the nature of the goods? What do we want to do with them? Do we really use perfumes the same way that we use scented candles? Probably not. You wouldn't put a scented candle directly on your body. You know, you wouldn't use it the same way. They're not interchangeable. They're not complementary products. Or would you find them in the same distribution channel? Would you find them next to each other in the retail store? If yes, it's likely they would be similar. Are they two goods in competition with each other? If yes, also likely to be similar. This is to say, all these canon factors will give you factual information to play with, because this becomes a factual exercise at this point. It's not a legal test anymore. You have to prove that the two goods are similar. How do you prove that? By saying, how do we use these two goods? And then it depends on the side that you want to prove every time. Third part of the equation, you have proved similarity of marks, you have proved similarity of goods. Then you have to prove likelihood of confusion. First thing you have to prove, who is getting confused? Average consumer, always. Average consumer of this specific domain, with all these things that we said about the average consumer of a luxury product, of a more everyday product, then depends. But does this part of the public that we care about believe that the goods that we have in question here come from the same undertaking? Or, if not the same, from companies that are connected to each other? Because let's say we had many cases in practice where I'm wearing a t-shirt, and in this t-shirt there is the face of a very famous singer, let's say Shakira. There is Shakira's face. Many people will go and buy this t-shirt because they will think that Shakira has licensed it. If Shakira's face is here, Shakira must have approved this t-shirt. She hasn't, though. She doesn't even know this. And Uniqlo did this. Uniqlo did this with Rihanna. Topshop did this. Huge places have done this thing. They have used the faces of celebrities. This increased the sale of the clothes because the consumers thought the celebrities are endorsing these products. And the celebrities didn't know how to sue, because how can you protect the use of your face? You cannot even trademark it. We said how you can trademark So this is how you assess likelihood of confusion. Likelihood of confusion, though, bear in mind, also includes likelihood of association. So if I think that Apple has like a branch that makes juices, this might also be likelihood of confusion. I don't think that this is an Apple product, but if I think that Apple is okay with this and Apple gives me the stamp of approval, and this gives very big added value to this. You understand that? I would never confuse it with an actual Apple product, but the Apple stamp of approval creates likelihood of confusion. Okay?
Okay, thank you, Prof, for the explanation. So I think this is the end of today. Thank you so much, Prof. Voutyrakos, for teaching us. You bring us an excellent and insightful presentation. It is an honor to us for have you giving lecture virtually. Thank you again, Prof. We hope all students enjoy the guest lecture as much as I did. I would like to invite all the participants here to turn on your camera to have some documentation and also virtual group photo shoot. Please turn on your camera. Wait a second. Okay, give your best smile. 1, 2, and 3. Okay, this is the end of for today. Thank you, Prof. And Assalamualaikum warahmatullahi wabarakatuh. Bye-bye, Prof.
Bye, guys. Thank you so much.
Thank you so much,
And
class.
I hope you liked our classes. And guys, stay in touch.
Yeah, stay in touch.
And Cheryl, can you send me also the picture to upload on my LinkedIn?
Okay, sure, of course. I will send it. Okay. Bye-bye,
Great.
Prof.
Not
You-
today's one with the t-shirt, the other one with the proper clothes.
Okay, sure. Yeah,
Bye,
Prof.
guys. Bye.
Bye.
Great to meet all of you. And Cheryl, thanks for facilitating this. It was very good, very well organized.
Yeah, Prof. Thank you. Kasih ya semuanya udah datang.
Yuk Kak maaf Kak. Yuk Kak, semangat ya Kak. Maaf hari itu nggak sempat ikut